strategy and balance sheet protection through economic cycles. A researcher and author on issues impacting the health, wealth, and future well-being of British Columbians, she speaks on succession, property rights, financing pressures, and long-term resilience. Rita?
Thank you for that wonderful introduction. Yes, tonight we're going to speak about the 3 layers of modern property systems. That includes the governance, the ownership, and finance. Next slide, please. Several of us in our group are in the financial area, and so before you make decisions in life, you always need to know how much money you have. The information on your chair tonight, BC is in massive trouble. We have, can you hear me?
Yeah, no, I don't think they got that brochure. Can you increase the volume?
Yes, yeah, BC has, we have a massive deficit and we've had a number of credit downgrades. And what we don't want to do is to create a situation where we get further in debt. Next slide, please. Our federal debt is $1.3 trillion, approaching that. So just to give you an idea how much $1 trillion is, if we still had a Canadian dollar, if you stack them, it would take 3 trips, almost 3 trips to the moon to make $1 trillion. Next slide, please. We all know what position our healthcare system is in, and so we have to be mindful that when we make decisions, there are items that we already need funding. So tonight, Adrian is going to cover the Declaration of the Rights of Indigenous People, which is a recognition, a formal legal recognition of the United States Declaration of the Rights of Indigenous People. So what we always want to do is be respectful of Indigenous people. What I'm going to talk about tonight has to do with what we can afford and the decisions that are being made. My family in particular, we've been here for 400 years. First Nations are within a number of our branches. So there are a lot of people in Canada and the United States that are descendant from both First Nations and original colonists. So we always want to make sure that we're respectful. Next slide, please. So one of the things before we start, I'd like to make sure that we're all on the same page with terminology. Fee simple and indefeasible title. An interest in the land recognized in common law and defined as the highest form of private property ownership allowed under the Torrens system, clarified in statute through the Land Title Act and the Property Law Act. Land under that is held individually, alienable, and can be transferred freely subject to statutory restrictions. The use may be limited by government statute and regulations, zoning, etc. And it's subject to the Crown's underlying title, including the Crown's ability to expropriate. Next slide, please. Now let's compare that fee simple with Aboriginal title. Sui generis, which means in a category all by itself, right to land that is not determined by common law or Indigenous property law concepts. It's held communally, it's inalienable, except to the Crown, including the inability to grant any material interest that may diminish entitlement to the land. The use must not be irreconcilable with the nature of the group's attachment to the land, and it's subject to the Crown's underlying title, including the Crown's ability to justifiably infringe. Further, since Aboriginal title is a communal interest that is inalienable except to the Crown, Aboriginal title holders cannot consent to or grant fee simple interest without first surrendering those lands to the Crown. Next slide, please. Recently, you've probably heard of the Cowichan tribe. The court decision. This is the map of the territory, which includes portions of Richmond in the Vancouver area. Next slide, please. Well, let's look at paragraph 3551 of this Cowichan decision. The Supreme Court of British Columbia stated that the provincial Crown grants of fee simple interest do not extinguish nor permanently displace Aboriginal title. The Cowichan tribe title lasted 11 years in total, with 6 years of active trial proceedings, 513 days of hearing, making it the longest trial in Canadian history and a cost of $100 million. Next slide, please. In paragraph 3543 of the Cowichan decision, this is what the judge said. I agree that the prospect that a declaration may affect non-parties consideration when determining whether to exercise my discretion to grant relief. In other words, she acknowledged that this decision would impact fee simple land possibly in the future. Next slide, please. So this is part of when your land is not your land, Aboriginal title versus fee simple title in British Columbia. The judge has suspended this ruling for 18 months to allow the government and the band to come to mutually acceptable terms. Given that few land settlements in BC have been finalized since the province joined Confederation, this seems to be a stretch. Regardless of this decision of the BC Supreme Court of Appeal, this case will almost certainly be appealed to the Supreme Court of Canada, which it has been. That process will likely take years, not to mention tens or hundreds of millions of dollars in legal fees, doubtless paid for by the government out of taxpayer money. Next slide, please. The judge in this case, acknowledging that the decision would create uncertainty in the real estate, whatever, this decision was made on the basis that Aboriginal title exists outside the provincial land title system, which we just referred to, the Torrens system, which we had always in the past thought of as being the highest level of land ownership. And Section 35 recognizes and affirms the existence of Aboriginal title and treaty rights of Aboriginal people in Canada. Because these rights are part of the Constitution, they carry a higher legal status than ordinary provincial legislation. Now, what this means going forward is that the court system has two legal frameworks that they have to contend with: the provincial land title system and the constitutionally protected Aboriginal title rights. Since Canada does not have an overarching constitution, you do have one, but that means that it relies heavily on the court system. This is going to be a difficult situation going forward and leading to a lot of litigation. Now, We were just dealing with that situation. Next slide. Yes, please. When all of a sudden, the government announced this decision, which is a rights recognition agreement with the Musqueam Nation. Next slide, please. This is the area in question, which includes most of all of Vancouver proper. Next slide, please. So what this is a negotiation framework and legal processes. This means that we're going to agree that an agreement needs to be reached. Once again, through either negotiations or through litigation. Next slide, please. So while we were researching that, we discovered that the Musqueam, just prior to this agreement, they have quite a number of taxation rights, including property transfer tax and property tax within the reserve. Next slide, please. So if you research what the Musqueam Reserve is now, this is the map you get. So we're not quite sure how those two are going to coexist. So this brings me to a discussion of the legal system and what I would call the legal industrial complex that we possibly are building. What is an industrial complex? Next slide, please. An industrial complex is a socio-economic concept wherein businesses become entwined in social or political systems or institutions, creating or bolstering a profit economy from those systems, such as a complex pursuit of its own interest, regardless of and often at the expense of the best interest of society and individuals. Businesses within an industrial complex may have been created to advance a social or political goal, but mostly profit from the goal when it's not reached. The industrial complex may profit financially or ideologically from maintaining social detrimental or ineffective systems. Now I'm going to quote from a decision in Ontario. This was a decision made that granted a $10 million settlement, which the court fees were in excess of $500 million. The court, $510 million to be exact, the court reduced it to reduced by $487 million. But the assistant professor at Osgoode Hall wrote that historically there have been concerns about lawyers potentially taking on lawsuits purely to enrich themselves. So the question that we have today is the legal system driving reconciliation and legislation into a circular reference that has no end in sight. And once again, given our financial situation, both provincially and federally, where does this end? Because we're not spending money that we have and that we've already earned. We're not spending that of our children or grandchildren. We're spending money for children that are not yet born. So these are the questions that we have to ask ourselves. Where are we going with this? And how much money are we prepared to borrow? Next slide, please. Because this is the list of land claims, and this is not a total list of claims. This is just one that's already been presented by the It's a very long list and will take a lot of money. And just so we're clear, when some of these claims are settled and you hear there's a $10 million settlement, there's a $20 million settlement, the these are IOUs. This is not that we're actually cutting a check and paying for it and we're finished with it. This is really just an IOU that someday, somewhere, may get paid if we have enough money to pay it. Next slide, please. And once again, getting back to the some of the claims have been settled, but there are some claims in negotiations. And there's a special claims tribunal that's been set up. That tribunal by itself can handle claims, and these are not land claims. These are claims such as breaches of the treaties that currently exist, mismanagement of reserved lands or resources, mismanagement of fraud involving First Nations, and issues arising from the acquisition, leasing, or disposition of reserved lands. This tribunal can issue amounts totaling $150 million per claim. So once again, we're just talking about the finances here. We're not talking about the legitimacy of claims or whether or not people have a right to funds. We're just talking about the finances. Next slide, please. So the 6 biggest developments since December have been that BC has officially filed the appeals, which has drawn a hard line. On February 5th, 2026, the province formally appealed the Cowichan ruling. And once again, as the attorney in one of my last slides said, this may take years, and this may take tens, if not hundreds of millions of dollars. Next slide, please. There's a new First Nations already filed a claim. You can see here, targeting roughly 650 hectares of fee simple land. Next slide, please. The banks are refusing to renew mortgages on affected properties. This is within the areas. These are not general properties in BC proper. These are just in affected areas. Next slide, please. And the province of BC has announced a $150 million loan guarantee program that possibly can help. Although the people that were in this area that owned fee simple land were not part of the lawsuit. And that's another thing that attorneys have pointed out, that people that are affected by litigation have the right to join the litigation. Next slide, please. The class action suit has been filed against the federal and the BC governments. We'll see where that goes. This is for misleading property owners. Next slide, please. BC and New Brunswick courts have reached opposite conclusions. So once again, this is the challenge with litigation, because since you don't have an overarching constitution whereby that can be cut off with, if it doesn't comply with a certain part of your constitution. So litigation can often lead to further litigation. Next slide, please. Next. Go through the next two. Next one. Okay, so this is a new term that some of you may not recognize: demodified property. Next slide, please. What decommodified property means is that property can best be served if it's not privately owned. So the Vancouver Action Plan, this was a 1976 meeting where the United Nations came to Vancouver, hosted by the then Premier Pierre Elliott Trudeau. And this was the preamble to that convention. Land, because of its unique nature and the crucial role it plays in human settlements, cannot be treated as an ordinary asset controlled by individuals and subject to the pressures and the inefficiency of the market. Private land ownership is also a principal instrument of accumulation and concentration of wealth, and therefore contributes to social injustice if not unchecked. It may become a major obstacle in the planning and the implementation of development schemes. Social justice, urban renewal and development, the provision of decent dwellings and healthy conditions for people can only be achieved if land is used in the interest of society as a whole. So Adrian is going to follow up with the United Nations Declaration of Independence, or of indigenous people, and the Declaration of the Rights of Indigenous People. And I would like to ask this question. Is everything that we're witnessing here in BC, is it only circumstantial, that it's only a local problem? Or are there other influences outside of British Columbia and outside of Canada that may be influencing this? Thank you.